Welcome to the 32nd lecture in this lecture series introducing the subject of international investment law. In the last lecture, we introduced the concept of national treatment and saw how the national treatment standard is reflected in bilateral investment treaties. We also discussed the implications of WTO jurisprudence on national treatment for the construction of those investment agreements. In this lecture, we introduce the factors to determine violation of the national treatment standard. The crucial question involved in determining a violation of the standard is whether the foreign investor and a domestic investor are placed in a comparable setting. But how to make this comparison? The basis for comparison cannot be narrow or broad. Therefore, the scope of interpretation of the phrases like situations or like circumstances become critical. In undertaking such comparison, the overall legal context in which the measure is placed will have to be considered. In the context of the NAFTA, the tribunal in SD Myers versus Canada held the concept of like circumstances invites an examination of whether a non-national investor complaining of less favorable treatment is in the same sector as the national investor. The tribunal takes the view that the word sector has a wide connotation that includes the concept of economic sector and business sector. Again, in SD Myers, the tribunal considered the following factors as important in determination of a violation of the national treatment standard. Whether the practical effect of the measure is to create a disproportionate benefit for the nationals over non-nationals. Second, whether the measure on its face appears to favor its nationals over non-nationals who are protected by the relevant treaty. Intent is important, but protectionist intent is not necessarily decisive on its own. The existence of an intent to favor nationals over non-nationals would not give rise to a breach of the national treatment standard if the measure in question were to produce no adverse effect on the non-national complainant. There has been some differences in views between tribunals on whether discriminatory intent is decisive. While the SD Myers tribunal held that intent was not decisive, other tribunals such as the Jenin versus Estonia and the Metanax tribunals seems to suggest otherwise. For instance, in Jenin versus Estonia, the tribunal held, moreover, claimants have failed to prove that the withdrawal of EIB's license was done with the intention to harm the bank or any of the claimants in this arbitration or to treat them in a discriminatory way. Tribunals have examined the violation of national treatment standard by taking into account the following aspects: whether a differentiation between a foreign investor and a local investor has taken place, whether such differentiation has taken place without any justification. More on this in the next lecture. Bye bye and stay safe.